and it's very hard to see through Mark. Disability Rights North Carolina is a federally mandated protection and advocacy program, so we protect the rights of people with disabilities. And that's one reason why I'm here and one reason why I asked to go last. Because everything we do is a reaction to what someone else does or does not do. That's what we do. We've talked about the big perfect storm and the little perfect storm. Let's talk about the perfect storm. Let's take that perfect storm to its natural conclusion. Anyone see the movie?
Oh yeah.
What happened?
They sink.
They die. The perfect storm results in death. What do you think happens to the 1,200 people who no longer qualify for personal care supports? What happens to them? They go into crisis. They go to the emergency room. If they're lucky, they might get out of the emergency room and go someplace else that's a little bit better. Many of them will go to jail because the emergency rooms will not be able to handle them. They will go to homeless shelters all across the state that are filling up at a daily rate with people with mental illness discharged from adult care homes. And many of our brothers and our sisters and our mothers and our fathers will die. Many of them will take their own life because they do not have the appropriate services. It's not the fault of any one system or any one individual. It is this confluence of factors that has led to a situation where people with mental illness and other disabilities frequently are the victims of service cuts, of misunderstanding, of stigmatizing behavior. So, partly how we got here is that North Carolina has never really sat down and implemented a full vision that looks at providing services to people with mental illness, and I have to say other disabilities, but tonight we're talking about people with mental illness, and fulfill that mission that Jim talked about in 122. Because when 122 was passed, all throughout it, there was a clause that said, as money allows, number one. Number two, we are looking at taking people with mental illness and putting them away so we don't have to interact with them or see them or deal with them on the streets or in the churches or in the community centers, even though it's cheaper. Jenny showed very, very clearly if we wanted to save North Carolina money in the short term and the long term, what we would do is fund appropriate community services and keep people out of expensive hospital stays. But where we're going with personal care supports specifically is in the opposite direction. We are going towards more expensive care, more hospitalization, and more stays in jail. And we are doing it at the expense of real lives, and we are not providing the services that those individuals need in order to recover their ability to contribute to society in many, many ways. There's a range of services. We have a good start with the agreement that the state just entered in with the Department of Justice. That agreement has good bones, but it's not sufficient. And it was never going to be sufficient. It was never intended to be sufficient. So what we have to do is something else. We have to stop shoehorning people with mental illness into a service definition that wasn't never really designed to serve them. We kind of took this service definition and said, let's see if we can put people with mental illness in there and find a way to pay for it. So we need to step back. We need to have a service definition that means real services, appropriate services for people with mental illness, and finally fix fully the problem. The state's existing definition is really used to stabilize housing, but yet we're not supposed to pay for housing with Medicaid. But that's what we're doing it to supplement to pay for the housing. So what we need is a service definition that is flexible, that allows for medication management, prompting, organizing, helping people organize their lives. It needs to be flexible across people and within us, because on any given day, I'm going to need a different kind of support depending on where I am. Today I can remember to take my medicine. Last Thursday I forgot. All right? So we need it to be flexible from one person to the next, but also within one person over time. So in order to get to this, essentially what we need to do is buy more time. Because we are out of time, folks. The personal care definition that we have before us was passed. It's statute. It's in law. It's state law. We have to live with it. It goes into effect assuming CMS approves it and doesn't throw another little monkey wrench into the whole thing. We are stuck with it on January 1. There is little we can do about that unless we buy more time. So what we need to do is to look at developing this service definition, looking at a blending of federal and state dollars, because it will take state money to do those things that you cannot do with federal money. And there are lots of moving parts. One solution, radical solution, because I'm supposed to, if you look at the agenda, I was supposed to come up with a solution.
It costs nothing.
Right. Actually, this will cost, because nothing is free and nothing comes without strings attached. All right, so there is something called PASHB. It's the litigation that my agency filed looking at and requiring comparability so that there was not a lower standard in adult care homes and group homes than there was living in your own home. So this state, for a long time, has made it harder to live in your own home and get appropriate services, and easier to go into a group home or adult care home and get the same type of service. And so we filed suit. We proved our case before the Eastern District and comparability, and Judge Boyle in the Eastern District issued a preliminary injunction that said until the case was fully heard, that everything was frozen. So, freeze. Services continue until he hears the case and both parties make their decision. The state went to the Fourth Circuit and appealed the preliminary injunction. And the Fourth Circuit granted a stay in about February, March, because the state convinced the Fourth Circuit that on April 1, that the I option was going to go into effect and fix all problems related to personal care supports, which I think we're on about our third iteration of personal care since we filed suit on June 1, 2011. What we need is time, and how we get the time is if the state would withdraw their appeal to the Fourth Circuit, which would lift the stay, which would mean the preliminary injunction would be in place and it would freeze status quo until we could work with the General Assembly when they come back in session in January